Hello students, welcome to all of you Shiksha 360, and today we have to start our session on the banking regulation and the banking laws. Okay, so let's start. As study material it is already provided you in the group for that topic. So now let's discuss regarding the MCQs. So that is, this is the set 1, and in this session we will try to discuss 10 MCQs that is related to the chapter number 28A. 28A basically topic, it is related to the company. So let's start our discussion, and I request all of you please participate in our discussion. The first question basically presents on your screens now. Which of the following, clear, the first question basically what it tells that which of the following it is not correct regarding a company. Clear, which of the following it is not correct basically regarding a company. So now let's discuss one by one. It requires a registration under the Companies Act 1956. This one it is correct or not? Yes, this one it is correct one. Clear, that is, it is to be required registration under the Companies Act 1956. We have to find that not correct. Clear, so A will not be the answer here. Second one, this registration it is with the company law board. Clear, this registration it is with the company law board. Clear, so we have not studied anything regarding the company law board till now. Clear, so we will kept pending this option. Third one, a company basically it is an artificial legal person created by the law. This one it is correct or not? A company basically it is an artificial legal person created by the law. Yes, this one it is to be also correct one. Here, fourth one, that is the company is dissolved by the process of law. Clear, the company is dissolved basically by the process of law. Clear, if we want to dissolve the company, so it is also dissolved basically by the process of the law. Clear, so this one it is also correct one here. Clear, so here option A, C, and D are to be correct one. So option number B is the wrong. So B is the answer here. Okay. So in this way, you have to try to understand the things. Clear. Only after that you are able to answer the question in the examination. This is not that much typical, but you have to give the answers very properly or try to understand all the things. Okay. So now let's discuss further regarding this question. So option correct answer is option number B. Now we have to discuss some other points regarding that. So what does say that basically section 3 of the Companies Act 1956, clear, section 3 of the Companies Act 1956 defines a company as a company. Clear, basically section 3 of the Companies Act 1956 basically it defines a company as a company formed and registered under this act. Clear, that is company it is must, that is they have to be registered under this act, that is Companies Act 1956. Clear, even if there is any existing company, they have also to register under that. An existing company means a company formed and registered. Clear, so what is the meaning of the existing company? Basically an existing company basically means a company formed and registered under any of the former Companies Act. Clear, so an existing company basically means a company formed and registered under any of the former Companies Act. Now move to the next one. Basically what the section 2 subsection 20 of the latest Companies Act, that is 2013. Clear, this act, this was further amended in the year 2020 also. Okay, so section 2, this is the section 3, that is there must be the registration. Clear, please remember that. Next one, that is section 2 subsection 20. Clear, section 2 subsection 20 of the new Companies Act 2013 similarly defines a company as a company. Clear, basically how it defines, similarly defines a company as a company incorporated under the Companies Act 2013. Clear, that are incorporated under the Companies Act 2013 or under any previous company law. Clear, or under any previous company law, which also means that those companies that were incorporated under the section 3 of the Companies Act 1926. Clear, that is here, that is what is mean that any previous company law, that is this one also, or any previous Companies Act shall remain within the brackets of definition of company under the new act. Clear, of the definition of the company under the new act. Clear, so that is they have to be registered further under this one. However, the term previous company law has been elaborated in the section 2 subsection 67, which lists all the previous statutes. Clear, that is basically which means all the previous laws. Clear, that is all are to be defined under that. Clear, sometimes they will ask in the examination, like under which section? Under the Companies Act 1956, that is section 3, and under the Companies Act 2013, under which section? That is section 2, subsection 20. Clear? Further, that is under the previous company law, basically it is to be elaborated under the section 2, subsection 67. Clear? Under the section 2, subsection 67. Clear? So kindly remember all these 3 points to be here. Clear? That is under the section 2, subsection 67. Now further move to the next question. Clear? So this is the question number 1, which we have discussed in detail. Now move to the next question. So next question number 2 here, that is the provisions of very important question. The provisions of which of the following act do not apply to a company due to the various judgments of the different courts? Which one is wrong here? Clear? That is, we have to find that which act do not apply to a company due to the various judgments of the different courts. So what is the correct answer? Option number A, that is Indian Partnership Act. Option number 2 is that is the Citizenship Act. Third one, that is the Constitution of India. Fourth one, that is the all the above. Clear? All the above. So which the provisions of which of the following act do not apply to a company due to the various judgments? Clear? Due to the various judgments of the different courts. Clear? Due to the various judgments of the different courts. So please tell fast in the comment section. What will be the correct answer here? So now let's discuss once again theory regarding that. After that, I will give the answer. Clear? So that is first point, that is a company has to be compulsory registered under the Companies Act 1956. Clear? This one is the correct one. Now, basically, which act is to be applicable or not? Clear? So first of all, what is company? Company, it is a legal person. Clear? Company, it is a legal person. So a company, it is an artificial legal person here. Clear? A company, basically, it is an artificial legal person here, which is created by the law. Clear? What is company? Basically, company, it is an artificial legal person here, which is to be created by the law and can be dissolved by the law alone. Clear? And can be dissolved by the law alone. Clear? So in the company, basically, which act is to be applicable? That is Companies Act 1956. It is to be applicable on that. So it is invisible, intangible, and exists only in the eyes of the law. Clear? That is, it is invisible, intangible, and exists only in the eyes of the law. It enjoys many rights of a natural person. Clear? That is, they have enjoys many rights of a natural person. So we can say that if enjoys, so Citizenship Act basically may apply on that because it is a natural person. But further, a company may enter into contract or in its own name, and it can acquire and dispose of the property. Clear? A company may enter into contracts in its own name, and it can acquire and dispose of the property, and can be fined under the provisions of the law for the violation of the law. Clear? If they violate the law, so they have to pay the fine also. Clear? If they violate the law, so they have to pay the fine also in that case. So further, however a company, clear, however a company, here they are saying that basically, however a company, it is not a natural citizen. Clear? However company, it is not a natural citizen like an individual. And courts have held that neither the provisions of the Constitution of India, clear, however company, it is not a natural citizen, clear, like an individual. Clear? It is enjoys the rights of a natural person, but it's not a natural citizen. Clear? It is to be created by the law. However, a company, it is not a natural citizen like an individual, and courts have held that neither the provisions of the Constitution of India, clear, neither the provision of the Constitution of India nor the provisions of the Citizenship Act apply to a company. Clear? Apply to a company. So thus, even though company has a nationality and domicile, it has no citizenship. Clear? Please remember that neither the provision of the Constitution of India nor the provision of the Citizenship Act, clear, applicable to the company. Clear? Even though company has a nationality and domicile, clear, but they have not any citizenship. Clear? But they have not any citizenship. Clear? So kindly remember all these points. Here I will see that basically all students, none of them basically will move towards the correct answers. Clear? Some are giving option number A, some are giving option number B. Clear? So what will be the correct answer here? That is option number Indian Partnership Act. This will not apply. The following, which of the following do not apply? This will not apply. This will also not apply. So what will be the correct answer? That is option number A, that is Indian Partnership Act. Clear? Indian Partnership Act. Clear? Option number A will be the correct answer here. Okay, so this will not apply here. This will not apply here. Okay. Here we have to find that which one is wrong. Clear? Which one is wrong here? These are don't apply. So option number A will be the answer. Option number A will be the answer here. Clear? B and C, they are already clear. Clear? The following provision of which of the following act, clear, do not apply to a company due to the various judgments. Clear? B is not applied. This one, it is to be correct one. C is not applied. This one, it is also correct one. Clear? And we have to find that which one is wrong here. Clear? Which one is wrong here? So option number A will be the answer here. Clear? Option number A will be the answer here. Now move to the next question. Clear? Now move to the next question. Clear? So in this way, they will confuse you in the examination. So you have to be very well aware regarding that. How they are asking the question. Clear? Here they are asking which one is the wrong here. Clear? This one, it is to correct one. It does not apply to a company. This one, it is also correct one. Does not apply to a company. Clear? So option number A will be the answer here. Now move to the next question. Question number 3. A company has a perpetual succession. Clear? That is on the death of one person, another will be appointed. So a company has a perpetual succession, which means that which one it is not a correct statement. Clear? And here we have also find out which one it is not the correct statement here. Clear? That is first one. It does not get dissolved. Clear? First one, that is it does not get dissolved due to the death of its member. Clear? Like if we can say that if any person expired of any company, like we can say the director of the company is expired. So we will appoint another director. Clear? The company will not dissolve in that case. We will appoint the another person. Clear? So here option number 1 says that it does not get dissolved due to the death of its member. Clear? So this one, it is correct or not? Yes, it one is to be correct one. So this will not be our answer. Clear? We have to find that which one it is an incorrect. Say this one, it is correct one. It continues as a separate legal entity. Clear? Basically, it is continues as a separate legal entity. This one, it is true, also correct one here. The insolvency of its members affect the existence of a company. Like if the members of the company are not able to pay their dues. Clear? So it will affect the existence of the company or not. It will not affect any existence of the company. Clear? The company has not any impact of these things. So option number C will be the answer here. Clear? Option number C will be the answer here. That option number C will be the wrong. Okay, so option number C will be the answer here. That is. Now we will discuss the option number D also. What members can come and go, but the company is continuous. Clear? This one, it is also correct. Okay. So here option number C, this one will be the answer, because this one, it is not a correct statement. Now let's discuss a little bit more regarding that. What is the meaning of the perpetual succession? What is the meaning of the separate property? Clear? So in this way, you are able to understand more. Please tell fast. Like this will be the attractive way, according to me, that you are able to understand all the points in detail after the question. So an incorporated company, what is the meaning of that? An incorporated company basically never dies. It is a legal entity. Clear? Company basically, it is a legal entity because it is to be registered under the Companies Act 1956 with the perpetual succession. The insolvency or death of the members. Clear? The insolvency or death of the members does not affect the continued existence of the company. In spite of a total change in the members of the company. Clear? Even if there are total change. Clear? In spite of a total change in the members of the company will remain the same entity. Clear? Even if there are all the members will change in that, even after that, the company will remain the same entity. Members may come and members may go. Clear? That is, members may come and the members may go, but the company goes on forever. Clear? Members may come and the members may go, but the company may go. But the company basically goes on forever. Clear? But the company goes on forever. Now, further one more point regarding that. This is the meaning of the perpetual existence. The next point which we have to discuss here regarding that is the separate property. Clear? So on incorporation, that is on registration, the company becomes the owner of its capital and assets. Clear? Basically on registration or incorporation, the company becomes the owner of its capital and assets, and the company is capable of holding property in its own name. Clear? Further, that is the company is capable. Clear? And the company basically it is capable of holding property in its own name. Clear? So this is regarding all the what we have discussed under the question number 3, all the important points regarding that. Okay. Now we move to the question number 4. Very, very important also. The company can be held liable only. Clear? What it says that the company can be held liable only when the document bear its signature. Clear? That is the company is responsible. Like it is only basically when the company basically it bear its signature. To ensure this, the company can be held liable only when the document bear its signature. To ensure this, what is specifically taken care by the banks as an extra precaution. Clear? That is what is specifically taken care by the bank as an extra precaution. First one, that is the banks get signature of all the authorized persons. Second one, the banks obtain a resolution basically from the board of directors of the company. The banks get the common seal of the company affixed on all the important documents. Option number D is all the above. Clear? Option number D is all the above. So here what they are saying that what is the extra precaution. Clear? That is here one thing. If they are saying precaution, so all the options. Clear? As an extra precaution. So while if we are like we are dealing in any like company, so first of all, what we have to do under that case, like if any organization presents you a check, like Rahul is the owner, Ramesh is the owner. So Rahul is the sign, Ramesh is the sign. Okay. So this is the sign of the Rahul, this is the sign of the Ramesh. And both are the authorized signatories. So you will pass the check or not? Please tell fast. You will pass the check or not? And the company, we can say that XYZ Limited. In this case, we will not pass the check. What is missing here? Clear? As this is the authorized signatory sign, date is also proper. Amount written, it is also proper. Clear? So what they are missing here? Clear? What they are missing here? That is seal. Seal is to be missing here. Clear? So this is the extra precaution. Clear? They have the signing authority only if they put the seal of that company. Individual capacity, they have not that much capable to do the sign in its individual capacity. Clear? They are able to sign only in the capacity of the firm. Clear? When they will put the seal, only after that they have ability to do the sign. Clear? So that is option number C. Option number A, that is, it is also correct one. Clear? Option number B, it is also correct one. That is while opening the account of the company, we will take the resolution from the board of the directors. Clear? Who will operate that? This is the requisite. That is third one, that is the bank to get the common seal of the company affixed on all the important documents. Clear? This is the most important, or we can say then an extra precaution. Clear? That is even while opening the account, or we can say that while giving any loan. So this is the important one. Clear? Because the individual have not any that much capacity to operate the account on the individual capacity. Clear? They are only capable to operate the account on the behalf of the firm. Clear? So here option number C will be the answer here. Okay. Hope you are able to understand. this point. So here I will discuss some of the important points regarding that are common seal. So as a company, it is an artificial legal person. Clear? It is an artificial legal person. It is not capable. Clear? It is not capable of signing documents of for itself. Clear? It acts through the natural person. Clear? It acts through the natural person. Who are the directors? Clear? Basically, it acts through the natural persons. Who are the directors? Basically, appointed by the shareholders of the company. Clear? So as a company, it is an artificial legal person. It is not capable of signing the documents for itself. It acts through the natural person. Clear? That is the company basically acts through the natural person. Who are the directors? Clear? Basically, who are the directors appointed by the shareholders of the company? Clear? Who are the directors basically that are going to be appointed by the shareholders of the company? However, it is a legal person. Okay. However, basically, it is a legal person and it can be held responsible. Clear? However, it is a legal person and it can be further held responsible for only those documents that bear its signature. Clear? That is, that bear its signature further. Hence, the law provides for a common seal with the name of the company engraved on it as a substitute for its signature. Clear? So here, if they will do the sign, then it is to be applicable. Clear? Like this is the firm stamp on that they will sign. Okay, any document bearing the common seal of the company, it is legally binding on the company. However, a common seal cannot be affixed. Clear? However, a common seal, like we cannot say that we are making the stamps from the market. Clear? And we are fixing and signing on that. Clear? This will not. However, common seal, that is, they have also given the authority. However, a common seal cannot be affixed by any director. It has to be affixed in the manner stated in the articles of the association. Clear? What is the meaning of the article of the association, which we have to cover in the later sessions? Clear? Example, in the presence of at least in the presence of two directors. Clear? In the presence of two directors, who shall sign on the document? Clear? In the presence of two directors, who shall sign on the document where the common seal is to be affixed in their presence? Clear? Where the common seal it is to be affixed in their presence. Clear? So like all these things basically is to be mentioned where, that is, it is to be mentioned in the form of in the articles of the association. Clear? All these things basically it is to be mentioned in the articles of the association. Okay. Now move to the next question. I think we have already discussed regarding this point. So let's discuss here once again. The common seal is affixed on the documents. Clear? The common seal is affixed on the documents. Option number A, that is, in the presence of the company representatives. Clear? The common seal it is to fix on the documents. Option number A, that is, in the presence of the company representatives. Second one, that is, in the presence of the representatives of the bank and the company. Third one, that is by the directors as per the procedure. Clear? That is by the director as per the procedure given in the memorandum of association. These are different things. Clear? Articles of association, it is different thing. Memorandum of association, it is a different thing. Clear? Or as per the provisions of the article of association, that is in the presence of the two directors. Clear? So here, which we have already discussed, that is, it is to be affixed in the manner in the articles of the association. Clear? These are very, very small points, but you will get in the examination in the form of the question. Clear? So sometimes basically what is the habit of the student, that is just go through the notes and practicing the question and try to cram that. Clear? No need to do this in way. Clear? Try to understand the things. Clear? This will represent you in a long run. So that is as per the articles of the association, that is in the presence of the two directors. So option number D will be the answer here. Clear? Option number D will be the answer here. Now move to the next question. A company, it is to be different. Clear? A company is different from a partnership firm in a respect of the following. Clear? In a respect of the following. And we have to find that which one it is the incorrect statement. Clear? And here, which one it is the incorrect statement we have to find here. Clear? Please remember that in the case of this subject, you have to just find the incorrect or correct. Clear? In the examination, they will ask the question, most of the question on the basis of that, and directly you will find that whatever we are discussing here, directly you will find straightforward question in the examination also. So now let's discuss regarding that. A member of the company are not agents of the company. Clear? That is, a members of the company are not agents of the company, but the partners are the agents of each other, basically in the partnership firm. Okay, the members of the company are not agents of the company, but the partners are agent of each other. Clear? So this one needs to be correct one. Second one, a company has a perpetual succession. This one, it is also correct one, which we have discussed. But the firm can be dissolved or gets dissolved. Clear? But the firm can be dissolved or gets dissolved. This one, it is also correct. The liability of the partners in a firm and shareholders in a company, it is to be similar. No, this one is to be wrong here. Clear? The liability of the partners in the firm and the shareholders in a company, it is to be similar. This one, it is to be wrong here. This one, it is to be wrong here. And we have to find out which one is the incorrect. So option number C, it is the incorrect one here. So this will be the answer here. Clear? So this one will be the answer. Now there are some of the differences. Clear? Now there are some of the differences which we have to understand here. That is, first one, that is the registration. Clear? That is the registration of a company. It has to be compulsory under the Companies Act 1956. On the other side, a registration of a partnership firm, basically it is not to be compulsory under the Indian Partnership Act 1932. Clear? So this one, it is the important, that is under the Companies Act, it is registration, it is to be compulsory for a company. On the other side, in the case of the partnership, registration, it is not to be compulsory. Next one, that is the number of members or the partners. Clear? Number of members of the partners. Here, that is minimum of 2 in the case of private company. Minimum there are to be 2 and maximum of 200 in the case of a private company. Minimum of 2 members and maximum of the 200 in the case of the private company, and in case of a 1-person company. Clear? Second one, that is in the case of a 1-person company as defined in the section 2, subsection 62 of the Companies Act 2013. That is, means a company in which has only 1 person as a member. Clear? In which only 1 person has a member. Third one, that is, as provided under section 3, subsection 1, a company may be formed for any lawful purposes. Clear? A company may be formed for any lawful purposes by 7 or more persons, where the company to be formed as to be a public company. Clear? That is when there is a person that is 7 or more. Clear? In the case of a public company, seven or more, and where 2 or more persons, where the company is to be formed as a private company. Clear? Where the private, that is 2 or more. Rest, there are some other conditions also which we have to follow time to time. As provided under section 3, subsection 2, a company formed under the subsection 1, this one, that is a company, it is limited by the shares, a company limited by the guarantee, or it is to be an unlimited company. Clear? So as per this, that is either the company, it is to be limited by the shares, or the company, it is to be limited by the guarantee, or it is to be an unlimited company. Clear? Or it is to be an unlimited company. And minimum number of persons. Clear? Minimum on the other side, that is in the case of the partnership of. Clear? So for the public company, minimum number members, it is to be 7 or more. For the private company, it is to be 2 or more. But in the case of the partnership firm, minimum number of 2 persons is to be required to form a partnership. Clear? And in the case of the partnership firm, that is minimum number of 2 persons is to be required to form a partnership. And the maximum number shall not exceed 100. Clear? In the case, that is in the case of partnership, the maximum number basically shall not exceed 100. Wide Rule 10 of the Companies Rules 2014. Clear? That is maximum number basically shall not exceed 100 in that case. Clear? Minimum number of that member, it is to be 2, and the maximum number shall not exceed 100. So this is regarding the explanation regarding the question numbers. Clear? So we have other questions also which we have to discuss in the next session regarding question number 7, 8, 9, 10. Clear? Along with that, in the next session, I will discuss some more questions. Okay. In the similar way, like first of all, we will discuss the question, and after that, we will discuss the detailed explanation of the same. Clear? Study material for the next session, I will upload in the evening in your group. Clear? So you can go through that. So in this way, we will cover this chapter. Clear, as it is totally theoretical topic. So we will cover this chapter in the form of the questions, MCQs, clear, or I will discuss some case studies also along with that, so that you are able to understand all these points. Clear. So thanks to all of you for joining this discussion. And if you like the content, so please share this video with your friends also.